I'm Tom Morello, and you're listening to the Ralph Nader Radio Hour.
Stand up, you've been sitting way too long.
Welcome to the Ralph Nader Radio Hour. My name is Steve Scrovan, and along with my trusty co-host, David Feldman. Hello, David.
Hello, Steve. This is very exciting. We have a full audience.
Got a full house here for our live Zoom event, which we always appreciate. And we've got the man of the hour here, Ralph Nader. Hello, Ralph.
Hello, everybody around the country and the world is watching.
Yeah, we've got Germany, we've got Cape Town, South Africa, as well as all across the country. And you're here on a great day, on a great program. Our guest today will be attorney Josh Koskoff, who has taken Remington and other arms manufacturers to court on behalf of victims of the Sandy Hook and Las Vegas mass shootings. Mr. Koskoff's work has held the manufacturers accountable in court. It has also forced a reckoning with the insurance companies, right-wing media, and others who have been profiting. Let's just put it that way, profiting off the dangerous marketing strategies of gun manufacturers. Holding negligent or malicious companies accountable isn't just about the money. It is, of course, partly about the money because profit-driven corporations only change when their bottom line is threatened. But taking companies like Remington to court allows the victims, their families, plaintiffs' attorneys, and the public at large to access internal documents that not only prove wrongdoing in the past, but help prevent harm in the future. And that is the importance of torts that if you're a listener to the show, you know we talk about all the time. So first, Ralph and Mr. Koskoff will go through the case. Then we'll invite our live Zoom audience to ask Mr. Koskoff some questions. As always, somewhere in the middle, we'll check in with our corporate crime reporter, Russell Mokhiber. But first, let's hear from the man who secured a landmark settlement in a case against the firearms industry that everyone thought was, quote, a losing proposition. David?
Josh Koskoff is an attorney specializing in medical malpractice and personal injury at Koskoff, and Beater. His work includes a recent $73 million settlement on behalf of families of the Sandy Hook shooting in a case against Remington, the company that made and marketed the AR-15 used in that shooting. Welcome to the Ralph Nader Radio Hour, Josh Koskoff.
Thank you very much to you, David, to Steve, and of course to one of my idols growing up, the first person I ever voted for, actually, Ralph Nader. It's a little bit surreal to be being on a program with Ralph, and I truly treasure it.
Well, thank you very much, Josh. And before we get into your groundbreaking case, let's talk a little bit about history. Ever since the Columbine massacre in Colorado about 20 years ago, there have been increasing numbers of these massacres by young men largely who were known as loners by their associates or neighbors and who harbored some grievance, had rather implicating websites to indicate how deep their torment was or their disassociation from their normal community. How do you explain that in almost all Western countries, for example, there are no such massacres? Japan has fewer arms-related deaths in the entire country of 120 million people than in a mid-sized town in the U.S. How do you explain this, and does it have anything to do with the enhanced weaponry, and does it have anything to do with the enhanced social media and the enormous publicity one massacre is given that tends to arouse some young person to do the same thing in another community? Give us some context here.
Sure, Ralph. And this is not an area that I knew much about 10 years ago. In fact, I was somewhat ignorant about the gun industry, and I certainly didn't know anything about gun laws, but I had to do my homework over the last 10 years. And I do think that, first of all, there's a lot to your question, not surprisingly. A lot of the factors, to point out one obvious factor, is the sheer number of firearms available and in private ownership in this country, something along the lines of 400 million firearms. And firearms, unlike other products that we know deteriorate over time, firearms don't. So, I mean, just ask Alec Baldwin, firearms, once they're purchased, and then they are useful to kill forever. So there's just that fundamental fact. But I think the interesting thing, what I took from my deep dive into the issues in the Sandy Hook case is that there were, in fact, always available AR-15s, for example, or what we would commonly call assault rifles in this country. When we were growing up, there were AR-15s, but we didn't know about them as kids or as young adults because the industry had no access to us. They couldn't reach us. They couldn't market to us, right? But they were always available. And we didn't have the mass shooting problem that we do. And I think you touched on it. And I think we would all agree, and all your listeners would agree, that being a troubled loner, a young kid going through the turmoils of adolescence or being bullied, that definitely we had when I was growing up. And I remember being on the wrong end of that kind of situation. But the gun industry couldn't take advantage of that. They couldn't try to acquire me as a future consumer or promise me an end to all of my problems with a glorious combat mission. And that did change. It actually really changed in about the mid-2000s, but it was probably changing before then. The Columbine kids got their hands on some pretty nasty firearms, but it was pretty much of an exception because really, if you and your audience think about it, the mass shootings that we're seeing that we think of have really all occurred in the last 15 years. And that's as a direct result of the ability of the firearms industry to reach minors and troubled young adults around the parents through the internet, through first-person shooter games. And it's also because of a deliberate effort to sell glory in these combat missions of lone gunmen. And so it's no secret, you have been on this issue for years, Ralph. If you market a product for a particular use, it's going to be used by certain people in that way. It's just human behavior, and it's why marketing is a multi-billion-dollar industry.
Well, the arms industry used to sell primary customers the Pentagon for use in wars. Then they would sell to hunters, and they would sell to marksmen. And now they're micro-selling more and more to different groups of people, including direct selling to what they must have known are troubled young men with fantasies. And you dug up the marketing messages for that in your suit regarding the Sandy Hook massacre against Remington. Can you describe just how detailed and tailored these advertisements were?
Well, it should come as no shock that because you see the tip of the iceberg of the marketing, which is, of course, the promotional material and the slogans and the emotional connection they're trying to make with a potential consumer. And the iceberg itself reflects a very deliberative effort to reach, to your point, and target an ever-expanding audience, notably a younger audience. Because I can't emphasize enough, the normal barriers that would have restricted a inappropriate or immature consumer in the days prior to the internet were obliterated. And the parent's role has been obliterated, such that the industry has taken full advantage of courting these young users with ferocious military weapons and promoting what is essentially a criminal use. And the parent has no idea what's going on. And so what we found in a general way, and we'll be releasing the documents to the public over the next 3 months or so, but is what you'd kind of expect, as if they were selling widgets, spreadsheets, PowerPoints, projections, deliberate efforts to target, as you note, a more micro target different segments that had previously been unavailable to the industry. And of course, they sell different messages to different targeted markets.
Tell us some of the phrases they used, which they knew would reach these troubled young men in their late teens and early 20s.
One is consider your man card reissued. I think people have seen that. Many people who are at least maybe peripherally familiar with the type of marketing. Prior to Bushmaster's acquisition, Bushmaster was a major manufacturer of AR-15s. There were only two, Bushmaster and Colt. And their marketing, I think, Ralph, I think you and I would even say was sober, responsible marketing prior to their acquisition by a private equity fund. And then there was an inflection point where they started a more aggressive promotion of not the weapon per se, but the emotion and the masculinity that the weapon conveyed. And so they equated ownership and use of an AR-15 with masculinity. So one of their ads said, consider your man card reissued. And in fact, you could even earn your quote unquote man card. You would get a card if you purchased one of these AR-15s. Another one was something that we made great use out of in a very tragic situation, which is they had a weapon called the adaptive combat rifle. And their promotion of that was forces of opposition bow down, you have been single-handedly outnumbered. Forces of opposition, bow down, you have been single-handedly outnumbered for a product that is being sold to any civilian kid, really, that wanted one. So that's clearly the promotion of a lone gunman mass shooting. There's no non-criminal use that could be described in that way in civilian life. That's a ambush. And then that finally, I'd say, and this will strike you all, I think, is harrowing. They had a promotion that said, clear the room, rescue the hostage, but clear the room. And when I put that question about clearing the room, and what could that possibly mean when you're talking about the commercial sale of an AR-15? How can you clear a room? And I asked them to describe, Ralph, take as much time as you want, Mr. Gun Executive, describe how you can clear a room with a commercial use in a non-criminal way, and they couldn't do it. It was like a deer in the headlights. And when I asked them whether they could think of an instance of criminal use of one of their weapons in which a room was cleared, invariably they had to agree that the Sandy Hook school shooting fit that description.
Well, describe for our listeners how much more powerful the AR-15 is compared to its predecessors.
Yeah.
And also tell them that it was once banned in the United States and what happened.
That's right. Well, let's start with the first question, which was very pivotal to my understanding of what an AR-15 was and its relationship to a regular firearm, to uncover declassified field tests of the AR-15 in the jungles of Vietnam, and reading about actual reports from soldiers who raided military weapons. The military was looking for a new battlefield weapon to sort of compete with the Kalashnikov rifle, or what folks know as the AK-47, which is sort of like the gold standard assault rifle. So this company, Armalite, developed the AR-15. And Ralph, there are actual ratings by soldiers in different categories: the tactical efficacy of the weapon, the lethality of it, the ease of use, whether it jams or not, its use in an ambush, and all these types of things that would be very helpful in the battlefield and taking on the enemy. And the AR-15 destroyed its competition, including something called the Thompson submachine gun, or the Tommy gun, as folks may know of it. And what I think is so telling about that is that the Tommy gun was effectively banned in 1934 by the government. It was really taxed into oblivion, but the concern was that it was too dangerous for our communities. And in fact, gangsters like Al Capone and Pretty Boy Floyd had used the Tommy gun in some very notorious mass shootings that today would hardly rate. They wouldn't even be on the front page of a paper. But everybody was freaked out about the Tommy gun's threat to public safety. And Democrats, Republicans, the NRA, and even Colt, the manufacturers, all got together to figure out a way to effectively ban the Tommy gun. So that's important when you consider that the AR-15 destroyed the Tommy gun in terms of its desire to be used to kill enemy combatants at war in these field testing. So what does that tell you about how dangerous this weapon is?
And when was it banned by Congress, and why is it no longer banned?
Sorry, the Tommy gun is still banned and led to the ban on automatic rifles. The AR-15, what we'll call assault rifle or AR-15 type rifle, and there are others in that category, but for the purposes of this conversation, we'll just call them AR-15s. They were banned in 1994, not just by Clinton and Democrats, but with the help of President Reagan, former President Reagan, who was very concerned about their use by criminals to effectively outgun the police. The concern at that time wasn't so much about mass shootings, because again, there really weren't any mass shootings with the AR-15 at that time. Of course, you didn't have the ability to promote crime, essentially, to sell the weapon that you do today. But putting that aside, there was a lot of concern about the police being outgunned, and they got it past Congress. But that had a 10-year sunset provision, so it would have to be renewed after 10 years. 10 years later, in 2004, we were at war with Iraq, and we had a different administration, and there wasn't a lot of energy. And the NRA did a pretty credible, did they do a good job lobbying? It's not a moral job, but it's a good, effective job. They did a good job lobbying Congress not to renew the assault weapons ban. It is also questionable whether the assault weapons ban had the desired efficacy. It wouldn't be surprising if it was wasn't the most effective legislation, because one of the problems I've seen is that, elected officials are busy. They've got a lot of issues to deal with, and most of them don't understand what makes a weapon dangerous and what doesn't. So the assault weapons ban was, in large part, they banned things that looked scary, right? Like a grenade launcher or certain stock, but they didn't really ban the core features of the weapon that make it so lethal. But in any event, there was just no appetite to renew it in 2004. And that led to, that of course helped sales as well.
Listen, I'm sure our listeners want to zero in on your case, your celebrated case that you brought against Remington. Nobody thought you had a chance. Go through the sequence, but first describe the massacre briefly that occurred in Sandy Hook, in Connecticut. And then there was other cases that were filed before you entered the litigation, just briefly, and then go into your litigation.
Okay, sure. First, the description of the shooting is brief because it was a brief amount of time. 4 minutes and 59 seconds, 156 shots fired, 26 killed, 20 children, all first graders between the ages of 6 and 7, and 6 adult educators. It's noteworthy that although from the first shot to the last shot was about 4 minutes and 59 seconds, the shooter wasn't shooting that whole time. Probably the shooter was shooting for 2 minutes or less. And that tells you all you need to know about the firepower of this weapon. There was one lawsuit filed right away that was instantly, and I think appropriately, excoriated by the legal community and the general public as being one of those opportunistic type things. There was another lawsuit that was filed against the school because there were issues about the failure of one of the classrooms to lock. I did not handle that case. It was not really a case that I was comfortable with, but as a principle of tort law, I couldn't say it wasn't a valid case, but somebody else filed that case. And we were really looking at whether or not there were any legal causes of action as it related to the weapon and its manufacture and sale effectively. And as it turned out, its marketing.
No, there were laws that protected the arms industry, including in Connecticut. They shielded them from any kind of civil action for the use of their weapons. And you found a statute in Connecticut that went into one of the exemptions under this Connecticut state law shielding the arms manufacturers, which is they had to not violate the marketing rules of the state of Connecticut. And that's where you found your entry.
Exactly. And I think this goes back to your original sort of observation, Ralph, about, how is more and more becoming a problem and when and where and why it happened. So in 2004, remember this, so you have the assault weapons ban lapsing. In 2005, you have Congress giving the NRA and the gun industry what was effectively a Christmas present and providing a thumb on the scale of the industry in what otherwise would be settled in courts, right? And we've seen this in other industries from time to time, but not quite like the gun industry. So they provided what was thought to be an immunity and is an immunity of sorts, but it's not an absolute immunity, and it never was. I think there was a perception prior to our lawsuit that you couldn't sue a gun manufacturer. I heard that time and again. I was luckily naive enough and ignorant enough about, and hadn't been involved in any cases, to be sort of weighed down by the pessimism. And what the immunity says is that it's called the Protection of Lawful Commerce and Arms Act. And it has a lot of protections, like it basically obliterates your common law negligence causes of action. But it's the protection of lawful commerce. It doesn't protect unlawful commerce and arms. And so what you're talking about is Connecticut had a state statute that prescribed certain marketing conduct. Every state has these statutes, consumer protection statutes. And we said, hey, that's a statute that is applicable to the sale or marketing of firearms. And you, Remington et al., broke that law. And that allegation withstood the challenge by the defendants to dismiss the case pursuant to the immunity. So we effectively got through that immunity.
And you found that Remington appealed it
Yes.
to the Supreme Court of Connecticut. You won there. They appealed it to the U.S. Supreme Court, which denied to take the case.
Yeah, I think if I gave the impression that this was a motion that was filed that was just granted, or that they lost and the case went forward, then I gave definitely the wrong impression. What I just described took years and years to sort out before we even, engaged in really meaningful discovery. And in fact, the trial court did dismiss the case, and it was the Supreme Court of Connecticut that reversed in part, because there was another part of the case that we don't have time to get into, I'm sure, but which I thought it was a valid claim, but the Supreme Court agreed with the trial court that it wasn't. But it didn't matter because we were greenlit and got through the immunity, which meant we got to a place that none had really been before in terms of a manufacturer, and that was discovery. So if you can imagine, it's like opening the doors to a cave, a dark cave that's never been explored. And that's how I kind of looked at it.
Well, listeners should know that Josh Koskoff is a very rare trial lawyer. Most trial lawyers would have been daunted by the corporate law firms representing Remington, and even after winning the legal issue, they would have settled for far less than Josh settled for his families at Sandy Hook or his clients. But he also demanded the production of documents, the internal memos, the marketing shenanigans, the boasting, and Remington resisted that. But he held firm, and he got a over $70 million settlement. But he also got, 30,000 documents, which you are now empowered by the settlement to release to the public as you wish and when you wish to further enlighten the marketing shenanigans of the industry.
Correct. I mean, it was closer to probably now 70,000 individual documents, some of which have many pages. Of course, a lot of the documents you get, as you know, Ralph, don't help advance any understanding of what happened. You get everything dumped on you. And so part of the process is curating those documents so that you are actually helping in the understanding to the general public and helping. And it wasn't, although I appreciate the kind words, really when you have families like this, they're resolved to get this done and to not settle for anything short of A, the full amounts of the available coverage, and B, but more importantly, the documents so that they could achieve the family's one main unifying goal, because they're all different people, remember, was to do whatever they could to help prevent the next Sandy Hook. So I really think, I grew motivation from their determination.
Kudos to those valiant families for persisting. And a lot of plaintiffs would have said, this has been an excruciating multi-year litigation. We're really impatient. We can't take the pressure anymore. Just settle. But they really wanted the public to know, and they wanted the case and the settlement to be a deterrent, as you say. That's one of the purposes of tort law, not just compensation, but public disclosure of the wrongdoing and deterrence against future repetitions. Well, do you see any deterrence among the arms manufacturers? Are they cleaning up their act?
No, I don't think they are cleaning up their act. From what I can tell from my early look at the Uvalde case and the Highland Park case and the Buffalo case, which is the same weapon that was used at Sandy Hook, so I already knew about that. From what I can tell from these other companies, they're drawing a page out of the same Bushmaster Remington playbook that delivered the Sandy Hook shooting and played a role there. I can establish really that it played a role. So look, I mean, I don't think it's a secret that the gun industry is not known for self-reflection or flexibility or even consideration of public safety. It's not just an industry.
How about its insurance companies like Liberty Mutual was one of the insurance? Are they putting pressure on their clients, the arms manufacturers, because they have to shell out the money?
Yeah. What's interesting, Ralph, to understand how this industry, the scale of the industry is really, really small industry, the gun industry is. We think of it as a massive industry because of the harm that it causes and the damage it does, 40,000 deaths or something like that a year. And of course, it has a presence in our daily life, almost unlike any other industry. But that is a perception that is at odds with the reality. It's about 1/50th. For every dollar of the tobacco industry, the gun industry is about 2 cents. So the reason I'm saying that in response to your question about the insurance industry is the insurance doesn't collect a lot of premiums from the gun industry. And I don't think that they were, from what I can tell, they are more hands off of the gun industry than they are certainly of my driving, my auto rates. I hear from my insurance carrier every time I get a speeding ticket, but I don't think that, from what I understand, the insurance industry, until our case, really didn't look into the practices of their insured. And I'm hopeful that one of the results of this will be that they will do that, because They are a great free market. I mean, of course, we all have issues with the insurance industry as well. But one thing the insurance industry can deliver is free market help in the face of public health crisis like the gun epidemic by creating a free market incentive to cleaning up the act of the gun industry. So I'm hopeful that happens, but I think that remains to be seen.
Well, are there going to be similar lawsuits, or are there similar lawsuits in the Buffalo massacre, the Highland Park massacre, and the Uvalde massacre against the arms manufacturers?
Well, I think that right now they're all under investigation, is my understanding. And full disclosure, our firm represents families in all of those instances. One thing I think is a step in the right direction, and I think you are probably, will sound like maybe deja vu of a nature to you, but 10 years ago, we had no competition for this case. No lawyer wanted to touch it. Even some of my partners, the best they could sort of muster was, good luck with that. And 10 years later, I'm finding that in the Uvalde situation forever, there are lawyers who really want to be involved, who really see a possibility or a path, no longer believing it to be impossible. And I think that one of the legacies, I hope, of the Remington case is that it did shatter that perception of invulnerability and engage trial lawyers who could be such a part of the solution here and who historically have been. And, I'm talking to you, who, of course, is the poster child of what trial lawyers can do. I mean, and we stand on the shoulders of people like you who have taken on other diseases. I'm not just saying that because you're interviewing me. I'm saying it because it's true. And people listening, I think many of people listening will be lawyers and many won't. But I think when trial lawyers are doing the best of work they can, they are having an effect that, helps communities and holds corporate America to task.
We're talking with Josh Koskoff, the plaintiff lawyer who brought the case against Remington Rand involving the Sandy Hook massacre and broke ground in this area. One last question before we go to the audience. I'm sure some of our audience are wondering about the lack of impact of public opinion. The vast majority of people in this country want background checks. They want safety locks. A smaller majority wants a ban on these automatic semi-machine guns. Even some members of the NRA want background checks and other gun safety controls. And yet Congress is still under the influence, at least for a workable opposition to gun safety laws, under the NRA. When do you think this logjam is going to break? Because we used to think that if there was a massacre every year, it would put pressure on members of Congress to change their minds. But when do you think that's going to break through, since you've been in touch with members of Congress?
Well, first of all, I don't want to give the impression that I've been involved in the political process. The reason I was in Washington recently was really just to support the Uvalde families and to shepherd them. I actually, by design, stayed away from politics in this case. And in fact, one thing I think I would have been aware of even 10 years ago was that the government had been almost historically impotent at dealing with this issue that we have, this shameful issue we have. And I don't think it is going to resolve anytime soon. And I do think that there could be, and there have been mass shootings, not just once a year, but once every other month, and it hasn't moved the needle. And that I think it is a parallel to the extremism that is the tail that's wagging the dog of politics, especially on the right today. Your point is well taken. A majority of the voting electorate would favor tighter regulations along the nature of what you said. But we're not in a majority, we're in a minority controlled capitalist situation right now. And that's not changing anytime soon. I mean, it's a very equivalent in my mind to the purism that would kick out one of the most conservative people that I've been aware of, which is Liz Cheney from a party, because she won't back an extremist theory. This is an industry the NRA is a lobbying agency that caters to its most extreme members. Because to be honest, they would sacrifice every person who buys 1 or 2 weapons in favor of the people who buy 10, 15, 20 weapons. And so they're not about to hack off their most voluminous buyers. That's a fact. I've seen the numbers. So that's your answer. And the NRA, so one more thing, because I think that one of the things that listeners may want to take from this, the perception versus the reality. The perception that the industry is a big industry, the reality that it's a small industry. The perception they can't be sued, the reality that they can. The perception that the NRA, that you have to abide by the NRA edicts or you're not going to get reelected, also may be inconsistent with the reality. But it's a strong and dangerous perception.
And the perception that the NRA and others pour campaign money into the coffers of these politicians is also a reality. Let's go to the audience, and people who are outside the country watching this should remember Josh Koskoff's estimate, which is pretty accurate, that about 40,000 gun-related deaths occur in this country every year, which is far, far greater than all the gun-related deaths that occur in all Western countries, including Japan and Taiwan.
We've been speaking with Josh Koskoff. We'll link to his work at ralphnaderradiohour.com. Up next, an exciting update about the Capitol Hill Citizen and a Q&A with our virtual audience. But first, let's check in with our corporate crime reporter, Russell Mokhiber.
From the National Press Building in Washington, D.C., this is your Corporate Crime Reporter Morning Minute for Friday, August 26, 2022. I'm Russell Mokhiber. A $1.7 billion jury verdict against Ford Motor Company involving a fatal truck crash called into question the roof strength of older model Super Duty pickups sold by the company over a roughly 17-year period. That's according to a report in the Wall Street Journal. Last week, a jury in Georgia reached a verdict in a case involving a 2014 rollover of a Ford F-250 pickup truck that left two people dead. The jury determined that punitive damages should be imposed on Ford for selling 5.2 million Super Duty trucks with what the plaintiff's attorney said were dangerously weak roofs that could crush passengers in a rollover accident. For the Corporate Crime Reporter, I'm Russell Mokhiber.
Thank you, Russell. Welcome back to the Ralph Nader Radio Hour. I'm Steve Scrovan, along with David Feldman and Ralph and Hannah Feldman. Hey, the September 2022 issue of the Capitol Hill Citizen is going to the printer. David?
For a donation of $5 or more to cover shipping and handling, we'll mail you a copy of The Citizen, hot off the press. To order your copy, go to capitolhillcitizen.com. You'll love the September issue, 40 pages of articles on the nonprofit industrial complex, a military-industrial complex lobbying group you've probably never heard of, and the Presbyterian Church condemning Israel as an apartheid state. It also features an article entitled The Black Hole, explaining our decision to go print only and the reaction to it. Again, for a donation of $5 or more, we'll mail you your copy of the Capitol Hill Citizen. Go to capitolhillcitizen.com.
Thank you. Indeed, this is a very unique pilot newspaper. It's getting rave reviews from around the country, even people who like print-only newspapers. And as a few more will come out in succeeding months, the editors hope that it will be self-sufficient and teach the mainstream press that covering Congress is not just official source journalism, that covering this metropolis on Capitol Hill with 33,000 people where everyone has a job and the enormous power Congress has to do well or bad for our country and the world is full of stories that need to be covered. And Capitol Hill Citizen does that in its 40 pages, every pilot edition.
All right, let's take some audience questions. Hannah, why don't you start us off?
This question comes to us from Jerome Jacobs.
Can the principle of holding manufacturers of certain products more responsible for injuries be applied to providers of various services?
I think that there's an often litigated issue about the providing of products versus the providing of services. And oftentimes we get into this in what is generally known as a products liability case. And, there are some things where of course, the line is kind of fuzzy. And so defendants sometimes want to label a case against a service rather than a product so that they can escape strict liability. But that's a general answer. And maybe if you were more specific about what you're thinking about, if anything, about the gun industry, I could probably answer that maybe a little more closely.
Okay, thank you for your question, Jerome. Who's next, Hannah?
This next question comes to us from Margaret Walsh.
Good morning. Hey, guys. Hey, Josh, have you seen any state shine, reporting reduced violence due to sophisticated system of gun injury and gun death data collection, perhaps motivating the CDC to study this. Thank you.
Have I seen data supporting, because we're all under the impression that there's been nothing but an increase in these things. And so have I seen any data indicating a decrease? I think the answer is no, but my personal answer is no, but it's not the same thing as saying that there isn't any. It's really hard, to measure whether a law that regulates something more tightly is effective or not, because you only know what happens, right? You know about the affirmative instances of gun deaths, but it's very difficult to measure on an epidemiological level what's been prevented. And so there's a little bit of a challenge in assessing the numbers. The thing to remember, though, is if you look at gun deaths over the course of decades, the deaths are certainly rising. But the other thing that happened over the course of decades is the advent of medicine. So more people are surviving serious gunshot injuries and previously would have died. So you have to look not just at the number of deaths, but the number of injuries. And so I think it's clear that we are seeing a steady rise over the course of the years, and it's only getting worse. And I do attribute, not all of it, but I attribute certainly much of it to the conduct of the gun industry and the failure of the United States government to rein in that conduct.
Yeah, Josh, also by comparison with Canada, it's like night and day. Our Canadian viewers might want to ask you a question. They're probably stunned at the difference, not only between Canadian gun safety laws and U.S. laws, but the compliance. And, Canadians like to hunt. They like to do a lot of the things, but their casualties per capita are far, far less than in the United States.
Our next question comes to us from Elizabeth Onan.
Hi, first I'd like to thank you for your heroic lawyering. And I'd like to ask if Mr. Koskoff could do for the victims of chemical, mainly pesticide injury, disability, and deaths, what he's done for the victims of guns. And of course, there are lots of other things I could put on your list. Thank you.
Thank you. Thank you for adding something critical to my list. That's exactly what I need right now. No, but I appreciate that, Elizabeth. Thank you so much for that kind suggestion. There are parallels in what I and my colleagues did here in this case to what Ralph did, decades ago, to what they did in opioids, to what they did in tobacco litigation. We're not reinventing every wheel here. And I do think that, the chemical industry, to talk about a big industry that does a lot of harm, you're right up there. I can only focus on so many things, but I think that especially if there's a particular issue, a particular chemical, and particular conduct you are concerned about, you should email me. And I do have a lot of colleagues who really focus on those types of cases. But I think gravity has pulled me in the direction of gun litigation, in addition to the cases that I really have handled throughout my career, which are the medical malpractice cases.
Our next question comes to us from Elizabeth Lehrer.
Hi, my question is there a Supreme Court ruling that you identify as paving the way for so much gun ownership, or as you say, this gun epidemic? Thank you.
Yeah, I think that obviously the Second Amendment, which we can't escape in any conversation about guns, even how much we try, obviously that's a problem in the way it's been interpreted. And that has moved, of course, as we all know, to the very hard extreme. More absolute, I think the Second Amendment is treated in a more absolute way than any other amendment I can even think of. And I certainly think the DC versus Heller case, in which Justice Scalia decided all that originalism and original intent he talked about for decades, well, for every rule there has an exception, I guess, in his way of looking at it, because he really bent over backwards to find a private right of ownership of a handgun in the home. And he relied on things like law review articles. I would fault DC versus Heller, but the truth is the DC versus Heller case is as much a reminder about the constitutionality on the limits of the Second Amendment as it is an expansion of the Second Amendment. And I think Scalia put in as many limits as he could because he knew he was kind of departing from his longstanding, orthodoxy. And then the recent decision in which they struck down the New York law, I think is deeply problematic mostly because it continues to reflect this false narrative, but strongly held belief that if you have a handgun on you, you are safer. Whereas there's no data whatsoever to support that. And in fact, the data would, or at least the anecdotal data would suggest otherwise. This idea that you're going to be mugged, and therefore in New York, putting aside the racial undertones of that and whatever the Supreme Court was imagining New York City's like, there's this idea that's just false. And that idea is so detrimental because until we decouple the idea that you're safer with a gun than without one, we're going to have a problem persuading people who could be persuaded.
Yeah, there's thousands of accidental gun deaths in the United States because of the prevalence of guns in homes, and kids get a hold of it, and one sibling, 5 years old, will shoot an 8 years old inadvertently. And I understand in Canada and elsewhere, you have to lock up your arms in your home. You have to lock it up so it cannot be easily accessed by children or others.
You wish the right would treat 5-year-old children with the same degree of protection as they treat one-day-old fetuses, but that's not the way it works.
Our next question comes to us from James Press.
Thank you so much for your very important work and for taking my question. I have a specific question with regard to something I read in the February New York Times article on this case. I think you called the checkmate moment in the case a piece of what looks to be evidence from Call of Duty, the video game. And so I guess my question is kind of growing up around the controversy of violence in video games and even a Supreme Court decision that declared that, free speech. What was the approach and strategy around the legal culpability of a video game developer? Is that something that factored into it?
Thank you. That's a great pickup. And I'm aware of the Supreme Court decision you're talking about, but only because I recently looked at it. It played a role because, but the way I looked at the video game part of the case was almost like that was the vehicle that the industry used to promote its weapon and reach these minors and irresponsible users that could be prone to violence. The more I've thought about it, the more I have come around to the idea that it's more than that, because the video games not only promote products that the user, mostly kids, can then go out and purchase at your local gun store, they are also working on repetitively autonomous system that gets activated in stressful situations. And because I had played Call of Duty, I understood that more than I think any lawyer who hadn't played Call of Duty. I'm not proud of the fact that I played Call of Duty. In fact, what I was ashamed of it, even when I was playing it, because I was a grown man, but I was even more ashamed of it after the Sandy Hook shooting and I stopped playing it. But as it turned out, my understanding of that game helped me to draw the connection between this marketing of this Bushmaster product and how that was checkmate moment, because I knew it reached the shooter because the shooter used a tactic from Call of Duty. And it's no accident that of the 30 manufacturers that were making AR-15s during that time period, the shooter wanted the Bushmaster brand because it was the Bushmaster brand that was in Call of Duty. So, we talk a lot in lawsuits about reasonable inferences. And I can say in malpractice cases, you almost never have that degree of a connection. You have to have a few more steps in between. Is it what we would call the smoking gun? Probably not, because nothing is, but it's pretty close. But to directly answer your question, I'm increasingly thinking that they are in an unholy alliance. The video game, particularly Call of Duty, promotes their product much in the same way that the gun industry promotes theirs. Now, of course, you can't go out and shoot somebody with a video game, but this would be along the lines of a type of a conspiracy, in my view.
Well, the video game business is getting closer and closer to proximate cause incitement. So maybe they will be a defendant someday.
This next question comes from Benjamin Moulton. He's asked me to read it. Given what Josh and Ralph are saying about deterrence, what would it take for the courts to increase the settlement payouts such that they would actually provide deterrence?
Well, it's a great question. It's confusing because although, and to speak from the settlement of this case, right? $73 million, I think everybody would say that is an enormous amount of money. But of course, we are used to reading about verdicts of hundreds of millions of dollars. So is it really a deterrence? And I think the answer in this case is yes. I mean, I know the answer is yes, because the $73 million wasn't really a settlement so much as it was a collection of every bit of the available insurance coverage, because Remington itself had gone into bankruptcy. So they could not contribute. There was no company left to deter, in essence, but more than that, there was no money from the company. They were broke. So it was important to the families and to us to make sure we got every dollar from every insurance company and, of course, the documents, because we wanted to establish that basically you cannot insure your way out of a mass shooting. And every time you sell an AR-15, especially in the way that you're marketing it and increasing the risk, you have just bought yourself an almost uninsurable event. And it's going to put your company on the line if such an event occurs. But it does take a sophisticated, thoughtful, responsible industry to respond to that. And I think that's where the difference is between the auto industry that Ralph dealt with for so many years and the gun industry. The auto industry is no icon of responsibility, but they are a more credible industry that did make changes and are now promoting safety features, largely because of the work that Ralph did, and responded to those bottom line issues that were also in keeping with a moral sort of compass. The gun industry just isn't like that. I can't describe it. It's a very threadbare, very unsophisticated industry.
And about punitive damages, Josh, was there any possibility of that in these cases?
Had we gone to trial, Ralph, we would have been entitled to punitive damages under Connecticut law, under violation of the unfair trade practices statute. Connecticut doesn't have the most robust punitive damages, but yes, we would have been able to get that. And I know those are not dischargeable in bankruptcy. Again, it wouldn't have been collectible because there was no pocket to collect it from. But that, of course, that's not the most important thing. If we didn't get the deal on the documents, it was no documents, no deal. That was what we said to them. At some point, it's rare, but I thought that this settlement, by combining all the possible amount of coverage and restitution and compensation, plus all of the documents, and I got additional depositions, I didn't think that spending another 2 years in court was enough of a payoff for the families, given that we had already accomplished so much, and certainly didn't want the Supreme Court to get another crack at this case.
Our next question comes to us from Rachel Branch.
Do you know of any other legal avenues that can go after gun manufacturers? And for example, RICO? Hi, John.
Yeah. Did you say RICO?
Yeah.
Yeah. Well, you kind of are speaking my language, I guess. I do think that conspiracy, RICO, aiding and abetting, these types of torts that we don't often litigate, but that are useful tools in tort law to get at a problem caused when you have these relationships. And certainly I have thought about, you have to both zero in and with the lens and also pull the lens way back, right? So I've thought about the gun industry sits at the center of a network of industries. Guns have to be shipped. They need the shipping industry. They have to be paid for. They need the credit card industry, and more recently, these layaway plans. They have to be promoted. Our discussion about, first-person shooter games. And they have to be insured. So, usually insurance companies are off limits, but as you still are required in a conspiracy case to prove an underlying tort or wrong. And so you still have to get through, if you're going to reel in the gun industry, you get back to the problem of having to get through the not absolute immunity. But I've thought about it, and not more than thought about it. I'm looking into it.
Our next question is from Doug Weissman. He's asked me to read it for him. Is there any type of legal action or breaking of the law that the running politician in Missouri could be faced with because of an ad showing him breaking into a home with law enforcement or military personnel, supposedly to take care of, quote, non-conforming Republicans?
This gets into the inherently fuzzy area of the limits of the First Amendment and the exceptions thereto. That's something we're dealing with right now as we prepare for trial against Alex Jones here in Connecticut in a couple of weeks. So I'm pretty familiar with the cases, and the answer is maybe. You'd have to have a plaintiff was standing to bring a lawsuit. It's as you probably know, just simply by the fact that it's abhorrent conduct and inciting violence, as Ralph alluded to, can be the case. Promoting violence, threatening, harassing. These are all things that, depending on this, very specific to the facts, you may or may not bring a lawsuit over, but you always need to have a plaintiff or a person who's alleging an injury of some kind to have standing to pursue that lawsuit. We can't just sue him because we think the conduct is reprehensible or tortious.
The episode that the caller, Josh, is referring to in Missouri was an ad placed by the former governor, Missouri, who was running for the U.S. Senate, and he lost the primary after that ad.
Yeah, no, I'm familiar with the ad, and I didn't hear that he lost, and I think that's welcome news especially to Missourians.
This next question is from an anonymous listener in West Virginia. They say, I live in the middle of Second Amendment country. Here, there are responsible gun owners and irresponsible gun owners. 80% of my neighbors voted for Trump and are 2A all the way. What kind of law would allow responsible gun owners to keep their guns while making sure irresponsible gun owners are curtailed?
I'm going to answer that question. But the thing that I thought was interesting about what we learned in looking into the Sandy Hook case and bringing it was that it really didn't encroach on the Second Amendment debate. Because I think, look, there are extremists who are never who we can put aside because you can't persuade certain people. But what I found is that, like what Ralph found in the auto industry, others found in other industries, at the end of the day, the problem was just as much about greed as it was guns. And it's really surrounding your question about responsible gun owner from irresponsible gun owners. Well, one of the things that could be done is the gun industry that talks all the time about responsible gun owners can start marketing their products to those people and not to the more likely class of people that are irresponsible. And they should promote responsible uses instead of promoting irresponsible uses. So in that way, that I wouldn't say mythological, because there are hundreds, millions of responsible gun owners in America. But in that way, the responsible gun owners should be able to say, look, why do I want some irresponsible gun owner to get acquisition of the weapon? Why do I want this gun company to market to irresponsible gun purchasers? That only threatens me and my family more, and my kids. So I do think that ought to be a point of some agreement. And in terms of what laws could be passed, this is what I found to be shocking. Another example of just the dysfunction in Washington, you had what turned out to be three, but at the time there were two very highly publicized shootings occurring very close in time, Buffalo and Uvalde, both carried out by kids under 21 with AR-15s. Think about yourself when you were 18 years old. And if that's too uncomfortable, think about your friends. And if that's too uncomfortable, think about the 18-year-olds in your class that you stayed away from. The ones that you were problematic. Maybe you wanted to reach out to them, but you knew there was something off about them. Do you really want them owning an AR-15? And is that the responsible gun owner that is being protected by this? Or is that courtship of that demographic irresponsible to all of us? So I'm getting to the punchline, which is just raise the age. Raise the age. I honestly think the age of all firearms should be 25 years old. Why? Because while we may be deemed adults at 18 by certain laws or 21 at others, those are just somewhat arbitrary. Biologically, we're not adults until we're 25. Don't take my word for it. Just ask the auto industry that won't loan you a car unless you're 25. Why? Not because they can't, they're prohibited from loaning you a car under 25, because the auto industry knows that you're not mature enough until you're 25. So if you raise the firearm age to 25, if that's the only law you changed, I think you'd see some enormous decrease in the amount of deaths and injuries caused by guns. And when was the last time you read about a mass shooter at a school or really anywhere that was over 25? I mean, it occurs, but by and large, you would have solved a lot of the problem. And guess what? Responsible gun owners like your neighbors in West Virginia can still get their hands on their AR-15, but they have to earn it by becoming adults first.
Wow,
and Congress still refuses to increase the age even to 21.
It's a shocking and appalling lack of political will. That's all I can say.
We've been talking with Josh Koskoff, the lawyer from Connecticut who brought the groundbreaking case against Remington Arms in the context of the tragic Sandy Hook massacre that occurred. with some 20 first graders who were killed and 6 teachers or instructors. And those of you who listened in might contemplate talking to your friends and neighbors about this issue. I think that Congress is beginning to be more amenable to some of these changes, including background checks supported by a great majority of the American people, and raising the age to 21 at least in terms of owning these automatic AR-15s. Thank you very much, Josh. Any last comments you want to make?
Just how grateful I am for this opportunity and for the really interesting and engaging questions of listeners. I hope you found it as rewarding as I did.
Yeah, thank you. To be sure, very good, perceptive questions over a broad range. Thank you, audience.
Thank you.
I want to thank our guest again, Josh Koskoff. For those of you listening on the radio, that's our show. For you podcast listeners, stay tuned for some bonus material we call the Wrap Up. A transcript of this program will appear on the Ralph Nader Radio Hour website soon after the episode is posted.
Subscribe to us on our Ralph Nader Radio Hour YouTube channel. And for Ralph's weekly column, you can get it for free by going to nader.org. For more from Russell Mokhiber, go to corporatecrimereporter.com.
The American Museum of Tort Law has gone virtual. Go to tortmuseum.org to explore the exhibits, take a virtual tour, and learn about iconic tort cases from history, much like the one we have done today. And be sure to check out the online gift shop. You'll find books, posters, and flaming Pinto magnets and mugs for all the tort fans in your life. That's at store.tortmuseum.org.
To order your copy of the Capitol Hill Citizen, Democracy Dies in Broad Daylight, go to capitolhillcitizen.com. The producers of the Ralph Nader Radio Hour are Jimmy Lee Wirt and Matthew Marin. Our executive producer is Alan Minsky.
Our theme music, Stand Up, Rise Up, was written and performed by Kemp Harris. Our proofreaders, Elizabeth Solomon. Our associate producers, Hannah Feldman. Our social media manager is Stephen Wentz.
Join us next week on the Ralph Nader Radio Hour when we feature another David versus Goliath court battle with attorney Mona Wallace and Corbin Addison, the man who chronicled the story that reads like a thriller entitled Wastelands, the true story of farm country on trial. Thank you, Ralph.
Thank you, everybody. It will truly be a gripping show on the giant pig conglomerates in eastern North Carolina, contaminating the lives of poor families there. And it's on its way to being a Hollywood movie with probably the same title, Wastelands. The book is out. The show is next week.
Hi, this is Jimmy Lee Wirt, producer of the Ralph Nader Radio Hour, and welcome to the Wrap-Up, where Josh Koskoff takes a few more audience questions.
Our next question comes to us from Ashraf. Ashraf has asked me to read her question. My question is about NRA and gun manufacturers in countries other than the USA, primarily Latin American countries. The U.S. withdrew from the Arms Trade Treaty, and after that, the NRA has been aggressively lobbying in other countries to sell firearms. Is there anything to be done about this issue?
First of all, I wasn't aware of that, and I think that's a terrible, terrible news for our friends in other countries south of us. The NRA is going through what appears to be a very tumultuous time, but managing to somehow stay on its feet. There's lots of litigation around it, its business practices. You know, I guess the only thing we can hope for is that those governments have more fortitude and sensibility to stand up to the NRA. It is a concern because I just imagining that their lobbying dollar down in South America probably goes a longer way than their lobbying dollar in America. And I think it's definitely cause for concern, but I don't have a solution other than there needs to be a strong pushback. I think that one thing that could be done if for somebody or an organization that was interested is just use America as an example, just say, look what happens when you open your pocketbooks to the NRA money and the effects it has. You want to emulate us in many ways. There's so much to emulate about the U.S. that's so great. This is not one of them.
This is another example of the U.S. not joining the community of nations and signing a treaty. The Small Arms Treaty was designed to control arms trafficking, like what's pouring out of the U.S. into Mexico and Central America. And I think there are very few countries that haven't signed it, but the U.S. is one that hasn't signed it, just like it hasn't signed the Child Protection International Treaty and many other treaties that over 120 countries have signed. Thanks for that question, caller.
Our next question comes to us from Steve Fournier. They've asked me to read it for them. They ask, the decisions on advertising were made by individual people. Has there been any move to sue them individually?
You know, I would have thought that, by the way. I thought that's how advertising and marketing worked. I mean, at the end of the day, a company can only make affirmative investments or marketing campaigns through people, obviously. But it's not really, I think it'd surprise you that it's actually a collective effort pursuant to a very, very calculated plan. Again, like selling any widget, the principles of marketing and sales, they don't really change that much from industry to industry. And you see people going from different industries all the time in the marketing industry. So I'm not trying to punt the question, but I've never really considered suing like the head of marketing, for example. You know, I think that you almost do injury to your case if you try to single out an individual when the problem is more of a deliberate corporate, scheme. I wouldn't rule it out. It would depend on what we found out the individual did.
This question comes to us from Jay Blackman.
Yes, hi. Yeah, I'd like to thank you for this fascinating conversation with you and Ralph on such an important topic. I'm thinking more of a political question. Do you think reversing the Citizens United decision would have any effect at all in loosening the hold that the NRA has on politicians who refuse to support gun control?
You know, first of all, I think reversing Citizens United would have a lot of great effects. I mean, we once lived in a world where there was some restriction, my understanding. Perversely, though, you could almost think of it as it might enhance the NRA's lobbying power, because the NRA operated very effectively, under more constraints, I think. And the Citizens United problem is really the dark, unaccounted for money and unlimited nature of it. I really don't know. I'm not sure it would have a direct result on the NRA and what that result could be. I guess I could see it enhancing the NRA's power and possibly diminishing it. But I don't think the NRA is really the type of lobbying organization, I could be wrong, that really is cashing in on the Citizens United decision. I mean, certainly other right-wing organizations that would promote similar values. So in that sense, it is very harmful.
For those who don't know, Citizens United was a Supreme Court decision in 2011 that allowed unlimited contributions as long as the contributors, corporations and other entities, didn't connect with the candidacy. They could oppose or support any candidacies, local, state, national, and pour money without limit, hundreds of millions of dollars. But they couldn't collaborate with the campaigns of any individual candidates. That, unfortunately, has not been adequately enforced, but that's what the Supreme Court ruled.
And that's a wrap. Join us next week on the Ralph Nader Radio Hour when Ralph welcomes attorney Mona Wallace and author Corbin Addison, the man who chronicled the story that reads like a thriller entitled Wastelands, the true story of farm country on trial. Until next time.
Stand up, you've been sitting way